is that really what will happen? And are we raising our expectations too high? Kwesi Kwakye Sebe is also a private legal practitioner. Join us on the line. Thank you very much for your time. Good morning to you.
Thank you, Senna, and good morning.
I hope you're well.
All is well, thank you.
I guess you were listening to your colleague, did you?
I joined halfway.
Okay. Any point of departure from what you listened to?
I think he was on point, but because I joined in midway, I think there's a point that he was not specific on, but it's eluding me at the moment. When we are talking and it comes in, I'll bring it up.
Okay.
You asked something about, yes, the 7 of the sentence.
Yes.
Whether it's...
you start counting from 2024 yes. Or this year?
Yes. In my humble opinion, the sentencing commences the day the judge handed over the judgment. So what it means per our laws is that if Sedina had succeeded at hiding in the United States for the duration of the sentencing, that would have counted as Sedina serving the entire sentence in the United States of America. That is the loophole I find in our law. I think it is an aspect that Parliament should take a very close look at and probably do some amendments or fashion a law that would deal with it, because it becomes unfair. What it means is that if you are tried, whether in absentia or you were present in the court, all you have to do is to try your best possible to escape from the hands of the authorities. Your sentencing starts. So if Sedina had been in America for the entire duration of the sentencing period, then Sedina would have been a free woman, and she would come to Ghana after the 10 years and do whatever thing that she wanted to do.
So as far as the court is concerned, the sentence, she started serving the sentence the day it was made. From the day it was made.
That is correct.
Interesting.
That is correct. That's the position of our law. The law does not permit the sentencing to take retrospective effect. No. Take a forward. What it means is that the very moment is handed. That is why when you go to court and you are found guilty, you are sentenced, you don't go home. From that very moment, you move straight to the authorities. Either if the processes are not completed, you spend some time in police custody, and thereafter straight to the prison. So there is no chance for anybody to say that I'm going home, I'm going to... The judgment is handed down. That is what the law says. Sentencing commences. The sentencing commences.
So
somebody running away, and then he comes to... I think even Honorable... Is it the press secretary, the president, or no? Information. I've forgotten the league. Came out with the release that he's going to begin his sentencing. To me, he's going to continue his sentencing, not begin, because it started August 2024 and not now.
I see. Then I think linked to that is a question I ask about that. Okay, now that the state has her, do they just take her straight to the prisons, or do they have any business with the court at all?
Yes, there should be some business with the court, because the identity of the person that has been brought in has to be made. That is the only thing. If he has to go to the court for it, that should be it. But you see, once the judgment has been passed, we say that the judge's authority over the matter is something official. The judge has finished his work. He's not going to answer any... The next right that you have is to appeal. Whether the judge went right or wrong, once he's giving the judgment, the judge is something official in the matter. is a need to ensure that the person who has been brought now and going to serve the sentence is the same person that was tried. That is the only reason why she may be sent back to the court, but not for the substantive or the substantial matter that has been dealt with. No.
And then I was also asking him what do you also make of the impact this appeal will make?
Well, regarding the appeal, in fact, that is one standard every lawyer will take. If I were to be in the position of state lawyers, I would have done similar, because the appeal is a right, despite the fact that she didn't make herself available. But they to go and argue why she was not available. If there is any justifiable reason why she was not available, it should be. I was not true. I wasn't in court. I don't know what happened. I don't know the excuses that they brought before the court. All those things are grounds for them to go and appeal. Even if but everything is done right by the judge in terms of satisfying his itself, the court satisfying itself that the person was fleeing, was a fleeing, to put it that way. Even if the court satisfied itself, the onus still rests with the Attorney General to prove the guilt of the person being tried in absentia beyond reasonable doubt. That hurdle, the Attorney General's Department or the prosecution must cross that hurdle. So, the ground for appeal will be whether or not that hurdle was crossed. If that hurdle was crossed, then the appeal, I don't know what grounds is going to then stand on and be successful. But if a threshold was not crossed and counsel for the convicted person can show to the appellate court that the prosecution failed to substantiate their accusation beyond reasonable doubt, then the convicted person can be set free. So what I expect from them is to, just like my colleague said, immediately once the appeal is pending, file for bail pending appeal. I'm told from some reports that it appears she is even not well. I understand that she, right from the aeroplane, I think she was in a wheelchair or something, with swollen feet. That is what I'm reading from some of the reports that are circulating. If all things are true, on health grounds, it can also be a very good position to take as counsel for Sedina. I understand those are the options that I see. But the appeal is her right. If she succeeds at appeal, she goes home. If she fails, whatever sentencing appellate court will bring, they can choose to even enhance the sentencing or reduce it. If you reduce the sentence, what it means is that yes, they have been successful in part. So what the court brings, we'll go by it.
I see. Then what about what I raised? Because I was thinking, having sat to court on many occasions, one of the things that people argue against bail is to say that the person is you must prove that the person is not a flight risk. Will that not come up?
It will. Certainly, somebody who was given the opportunity to come and defend herself, granted bail, and if the case and the fact, as we heard it in the media, is true, that she just left the country and decided not to return, and for the judge, at this point, for the judge to accept the argument of the Attorney General then to try Sedina in absentia means that she was running away from justice. So if such a person is brought before the court again, then one can easily make the argument that she's a flight risk. If she is, can there be a better measures put in place so that we ensure that she doesn't leave the country and she deposits her passport and they refuse, even if I think in the past the passport was part of the bill when he deposited the passport and said he wanted to go for health, go out on health or something and never return. So you will see that it will come, it depends on the arguments that are going to be made on the day to convince the appellate court whether or not to grant her bail or not. The fact that she left the shop and never returned does not necessarily mean that she cannot be granted bail. Bail is still her right, but it depends on the arguments that are going to be made and the circumstances under which she was not able to make it back to Ghana. So, in fact, in court, it's always not a one-way traffic. It depends on the specific facts that will be put before the appellate court, and they will make their own determination about that. So, yes, although that has happened, it does not prevent her from getting bail. But the only reason is the other header will be that, as you just said, that will be difficult. That will be difficult. Looking at a past record, that there should be a header for her to find.
And I'm guessing that her lawyers have already considered that. In fact, you are a member of the opposition. One of the things people have argued for when the Kenoforiata matter has come up is this, that there should be fairness. That in her case, there was even a judgment of the court. And that makes it easier for the state to go after her whilst also pursuing Ken Oforiatta. Now that she's in, do you have any reservations? Because already I hear people expressing reservations about whether or not government will do the right thing as expected of them.
As far as the courts are concerned, I have confidence in them that they will do that which is right. But, Senator, trust me, I don't trust the current administration to be just and fair with this Sedina case. And it's rather unfortunate they are the people who are also going to represent the state. You see, the record and the are not good as far as this current administration, the NDC administration, John Mahama II, is concerned. I say so because, Senna, we are in this country that to becoming the office of President Mahama this very time, and then for that matter, there were people standing trial in court who are linked to the NDC. Virtually all of them, really the key ones. The Attorney General finally prosecuted, meaning that he was no longer interested in the matter. Even in a case where the court has dismissed an application for what do you call it? I think they filed for that there was no case against them made against them. The court looked through the matter and said, no, you have questions to answer. Come and answer. Now, a new Attorney General comes and says, I filed I find no question for them to answer. They should go home. In the case of the situation, regrettably to say, shamefully enough, the Attorney General told us that he spoke with J.T. Pence's lawyer in the person of the revered Chatuchi Kata. And the revered Chatuchi Kata said that he wants to continue with the case. So for which reason the Attorney General left that case. So the Attorney General is supposed to defend the state. Tell the accused person's lawyer that, oh, let's use this route. Say, no, I want to defend myself to the end, because he wanted to show to the world that his client was indeed innocent of the matters. And if this same Attorney General that is going to stand in people against Tamakle, what's going to happen? So even if the right thing was done, and I believe the right thing was done for the equation, what the Attorney General came to tell us alone should be a source of worry to all of us. Again, you see, Lawyer Martin Toby, he's one of the people, the first group that the then president-elect, now the president, appointed to do certain, I think the oral team, he was a member of the oral team, was appointed. So I can fact back. It's either he's working on the corridors of this government, or he's very close. And if you look at all the communications that he's having, political communications and his commentary, it is clear that he sides with the NDC government. What did he say about Sedina when Sedina was still outside the country? Martin Pepper said, in his opinion, Sedina should come to Ghana. He should be given a preferential power. And if he starts for about 1 or 2 years, the president can pardon him. So it is a prayer that Sedina comes. So if people in these positions are saying these things, we expect that Ghanaians think that fairness will prevail. If the NPP should come and tell us that if Sedina's trial was also pending with that of the others that he granted not the prescribed, we'll see have also been granted that opportunity or not. So you see, with the Attorney General we have, and with the government that we have in place that seems to protect its own, they were not into what you call BNI and remanded for years. They were taken to court, granted the opportunity to defend themselves. But the Attorney General said, no, I'll let them defend themselves. Let them go. Because he tells us that, I think, Honorable Kwabena has made some payments and other things. Somebody filed questions and the AG is found wanting. So if there is a clear plan to protect NDC members that did wrong in the past. What happened when this gentleman, Kevin Taylor's issue, somebody that the court has placed a bench warrant for him, should be arrested the very moment he steps foot in Ghana, but he was given protection, not through court, just the verdict court. In fact, I must say that the decision that the Supreme Court came up with, I agree with 100%, because the man should have been given the opportunity, like Kevin Taylor, to be heard. I agree perfectly that the processors, that somebody who commits a crime against the state that person protection. Why? Because he's either an NDC member or he aided in the president's success and the NDC's success of coming into power. That is wrong. That is very bad. And that is very shameful.
Okay.
So to me, if you say that this Attorney General is going to make cogent arguments against Sedina Tamakloe, in fact,
okay,
that would be the probably the 15th wonder of the world.
So that assumption is based on appeal that she has filed.
Yes. The appeal that he has filed. To me, I have no confidence in the Attorney General that he's going to actually defend it. Like he's chasing would be. I don't think he will have that strength to go and oppose the application, the whether bill. I don't know whether bill has, but at least the appeal. I don't think so, because I believe strongly with all that whatever he has done in the past, if Sedina's case, but if Sedina has not left the county, it is very foreseeable that the case wouldn't have ended in 2014 because it was a time for her to also open a defense and possibly try and drag the matter till after the election. So if Sedina had been here, gone through all the processes, a judgment never came before December 7, 2024. I can tell you this as the engineer would have filed knowledge of the car and then allowed matters to rest.
Are you not comparing apples to oranges? Because in this case, the government formed from the party that you belong to secured a conviction, a sentence that she is obliged to serve. Now, you are comparing unconcluded matters with a concluded matter. Where is the comparison here?
Which one is the concluded and which one is the unconcluded?
The ones you're talking about filing nolle prosequi were
Yes.
not concluded matters, were they?
Yes.
In this case, it was concluded. A judgment handed down.
Yes, but it's not concluded because an appeal has been raised.
But
So we're going back to court.
But the appeal is not. Are you suggesting that what the AG argues or does not argue can lead to the decision being overturned without the court expressing its opinion? Ultimately, is it not the court's decision to make?
It is the court's decision to make. But it is for the Attorney General to explain. You are there to convince the court that you leave all matters to the court. Just file your pleadings and allow the court to come up with its own verdict. That is the reason why Attorney General is being paid by the state to defend state. What you are saying, if that is the case, then when somebody files an appeal, there is no need for the Attorney General to go in and respond to the matters that have been raised. Then there is no need. We should just leave it for the court to come with its verdict. No, the Attorney General is supposed to make legal arguments.
In this case, we haven't even gotten there yet, have we?
Well,
We haven't gotten to the point where arguments are being made. What position the Attorney General will take, you don't know.
No.
I do not know, do you?
What I'm saying, I didn't get you right. I have no confidence in an Attorney General that is back to set free NDC appointees that is wrong or perceived, let me put it that way, to have done something wrong. With all the non-prosecutors that he filed, the issues against NDC appointees and chasing NDC after. Look, one issue that you know that is a planned thing of this government. They said they were going to do ORA to recover but some loot, all loot. If you are recovering all loot, recover all loot. Why are you limiting the tenure of Kufuor? So you will see that in the oral report, anybody that reported anything outside of Kufuor's regime was rejected.
Okay.
All those matters were cut off. Just out there, do it in a federal government.
Okay.
The serious government is ready to fight corruption, left, right, and right.
Okay.
Corruption is not against it.
Okay, you have made that point abundantly. I just want to conclude by asking you, do you believe an individual can hold an independent opinion?
An individual, yes, and that's not the question, but in this sense, can you elaborate? Who is that individual? You mean the Attorney General?
Not the Attorney General. Can you hold an independent opinion that cannot be put into the bracket of NDC NPP?
That is correct. I can.
Okay. Are you saying that Mr. Lawyer Martin Kpebu cannot hold an independent opinion without you insisting that he has to be put into the straitjackets of either NPP or NDC?
He can. I even said that he gave his opinion, but I'm linking it to the fact that he is somebody that cannot be an ordinary person. Let me put it that way.
That's been appointed to do a job.
Yes.
Ultimately mean that everything you say should be put into the jacket of NPP, NDC.
No. But everything you say can be measured with not necessarily because he was appointed. Or in just recently, I think last week, he came up to say that when the NPP comes to power, he was speaking with certain that the bail conditions that this current administration is pursuing is too excessive. We should be careful because when the NPP comes to power, some of us that have been speaking for the NDC, they will come and arrest us.
He says some of us that have been speaking for the NDC.
Yes, he said it. He even mentioned the president's name, that he liked the president. He voted for the president. Find the tape. I think it was.
But he also said he voted for Nana Akufo-Addo. He liked Nana Akufo-Addo until he felt that what Nana Akufo-Addo was doing wrong. And I'm saying that do those words necessarily mean you must be a member of the NDC or share an NDC opinion to comment independently on a matter?
What I am saying, Senator, the reverse of your question is also true. Yes, it is true. So if it doesn't help, that's why we say justice must not only be seen to have been done, but it must be manifestly seen. It shouldn't just be done. It should be seen to be done. So if we have government, people close to government, like Martin Tebu, close to the NDC, like Martin Tebu, is on all platforms canvassing for the NDC. He tells us recently or currently he's in bed with the NDC. If he says such things, you think it's not worrying? It is. Then I say,
I see.
It is worrying. It is an opinion. But his opinion carries higher weight in this government than myself. Sitting here. Because that's why I said it's either he's walking on the corridors of power or he's close to corridors of power. That's what I said.
Lawyer Kwakye, thank you very much for speaking to us.
Thanks for having me, sir.
He's a private legal practitioner and also a member of the New Patriotic Party. Taking us exactly 42 minutes past 8. We are still expecting Prof. I don't know if Prof is around. He's now coming. The other Prof can come in. But you say you are a Prof. Charlie. Okay,